good candidates for this, like really less severe, you know, not a very severe crime, bumped up to Tier 3. Call Miriam Ackerman. She's now with ACLU. You can find her in the Bar Journal, and she'll look at them. She's trying to get 4 or 5 of them. So for Tier 3, they have to go 4 times a year to the police station to verify their information. And you'll see, so CSC 4 is Tier 3 if the person, the victim, is under 14 or is under 13. So that's, you know, a lot of times you might think, oh, CSC 4 is a great plea bargain. Well, they're going to be lifetime registration. I had this question. I didn't know it until I figured it out. Somebody called me and said, I have a juvenile court case, and it's a CSC 4, but my client is under 17. Wait, I don't see him in the tiers. Well, that is intentional. They don't have to register at all. In juvenile court, if you can get a CSC 4, then they don't have to register because the legislators wanted to give some sort of plea bargaining tools to the prosecutors. And I already talked about the catch-all and juveniles, expungements. And now I will, any questions right now? I will talk about, yes?
How do you spell
Ackerman? A-U-C-K-E-R-M-A-N. You're welcome.
Did you say the good stuff is retroactive?
What good? Yes.
Yes? Okay.
Right. Oh, yeah.
If you're under 17, if you're under 14.
Yes, that's all retroactive. Yeah, so even, yeah, the good stuff and the bad stuff's retroactive.
Okay.
And you will get, and that's another good point, because you'll get clients calling and saying, I'm on Tier 2, I should be Tier 1, and you look and you say, yeah, that's right. Michigan State Police, as best as they tried to do everything accurately, but they didn't. This was a massive undertaking where they had about 2 months to revamp the registry. They had 46,000 people they had to reclassify. There are mistakes. And if you have a client calling you saying, I think there's a mistake on how I was tiered, or I was a juvenile and I'm still on it, that Karen Johnson, the number I gave you, send her the supporting document to show that it was a wrong tier or it's a juvenile. She will fix it if she can corroborate it. If not, you go to the sentencing court and correct it.
Okay, that was my next question. So specifically thinking post-conviction, they were sentenced before the changes in the law.
Right.
Post-conviction, but it may have involved consensual between the parties and those they need to be cited. So you can go back to post-conviction.
Yes, it's in the law.
Okay.
I'll get to that in 1 second, how you do the petitioning procedures. It's in the new statute, which gives the registrants a right, if they fall under one of the classes, to go back. You go back in front of the sentencing court, even if it's a new judge and got reassigned, you go back there and file the petition that gives them jurisdiction. Another argument I have, and I'll talk about it, in cruel or unusual motions that you can do. So how do you keep your clients off the registry? HIDA, if they're eligible. Oh, we try to get HIDA. And don't let your, and I've had this, where I've had a client who violated probation, and the choice from the judge was, I'll revoke your HIDA or send you to HIDA prison. I tell my client, prison. Yes, Peggy. I said, go to the thumb. He went there for 2 years, because you can, with HIDA, you can go up to 3 years in prison. It's a flat term, not the range. It's flat. And you got to tell the judge that, and you got to make sure the judge knows, and you got to educate your client, because they might just say, take away my HIDA status. I don't want to go to prison. And say, client, you don't realize if they take away a HIDA, you're going to have a lifelong prison sentence. And you got to explain that to judges on probation violations. Try to protect HIDA as best as you can, anything you can do. So for HIDA, and you can get HIDA for CSC 3, victim between 13 and 15, CSC 4, victim between 13 and 15, defendant not more than 5 years, assault with intent to commit, any one of those 2, any other listed offense, unless it carries life imprisonment or CSC 1, 2, and a new law with the expungement statute. Well, that wouldn't change it, because you can't expunge anymore the child sexually abusive activity, but you can still get HIDA for it, can't you?
Well,
you could before, because I had clients who did. I think there was a
Well, you weren't supposed to before unless they changed the law, and then
They did.
You can now. So before, you couldn't get HIDA for any offense that was registratable, with the exception of CSC 3 and 4.
Yeah.
Now, if you're saying they've changed the statute, I haven't seen it.
Yeah, that's in, yeah, look on my page
There you go.
10. You can, and always it was assault with intent to commit one of those CSC 3 or 4s, you can get them. That's another thing I had to educate somebody on. And I think the laws changed where you can't get it anymore for child sexually abusive material, but I had an old client who got HIDA for that.
He shouldn't have.
Oh.
It's okay.
Another, yes.
Cheryl, when they're talking about adults or juvenile at the time of the conviction, what do they do with a juvenile who gets wavered up?
That counts as an adult. I know. So if you have a 15, 14-year-old who's waived up to circuit court, that's an adult. They're not treated as a juvenile. So try to keep them in. I don't do much juvenile adjudicated or disposition work, but try to keep them there if there's a way. Another way to keep your client off the registry is new cases where the judge doesn't give HIDA, but you can prove it was Romeo and Juliet. And look at page 10 of my handout. This isn't retroactive. This only applies to cases from July 1st of this year onward. HIDA is not required. You have to have a hearing before sentencing to show consent. The victim's between 13 and 15, and there's not more than 4 years age difference. And you're like, well, what do we do at the hearing for this kind of case? I haven't done one of these hearings, and I think it could be a free-for-all if it's really contested by the prosecutor, because the rules of evidence don't apply except for Rape Shield Act. So if you wanted to bring to prove consent and you had a girl who was, the basketball diary case from West Bloomfield where she was sleeping with all the basketball players and wrote it in her diary, and you're like, Judge, this shows consent. She went out and had sex with all these boys. You can't bring that in because it's protected under Rape Shield. And you have to prove it by preponderance of evidence at the hearing. And also, under old cases where the person didn't get HIDA, you can file a petition now, even if the case has been closed for 10 years. Look at on page 11, it shows it here. It's MCL 28.728C14. And it's important here, how it reads is the court shall grant a petition by an individual if the court determines the listed offense was a result of consensual sexual activity and any of the following. And these are all really aimed at teenagers. But I've found it important when I go in court on these cases to tell the judge, Judge, you don't have discretion. You shall. The only discretion you have, Judge, is whether it's consensual and the ages apply. The prosecutor might be saying, well, this kid got into so much criminal trouble after the fact, or he's in drugs, or this is his behavior, or say, Judge, that's not relevant for this type of petition. You have no discretion. The only thing is consent and the ages. And if you find consent in the ages, Judge, you have to grant the petition. And if you do, and if you're successful, get an order and be specific in the order why the judge removed the person from the registry, because I've talked to Karen Johnson and sometimes she gets orders that say, court finds a defendant should not register as a sex offender. Karen gets it and goes, why? What's the reason? So be specific and put the statute, and the judge found consent and all of that. Fax it up. I always take it upon myself to take that order, fax it right away to her. I don't wait for the court to do it, because that sometimes it can get lost or it doesn't happen. And you're wondering, let's say, how do you prove consent for one of these petitions? It's like my dad said, you've got to know your client, and you've got to know what happened back then. Because a lot of times you'll just have crazy case facts for these teenagers.
Cheryl, in the nightmare scenario, you can't find the complaining witness.
Yeah, Mike says you can't find the complaining witness, because that's one thing I do. We have a right. I always have an investigator do it, and me talk. I call the complaining witness if it's a case where I think she's going to say it's consensual. It's amazing, though. A lot of times they won't say it's consensual, or they won't be helpful. I've had that. If they will say it's consensual, get an affidavit from the complaining witness, attach it to prove consent. You can have her come to court at the hearing. Prosecutors are obligated under the law to contact the complaining witness. So don't think, well, I don't want to open up this can of worms, because they're going to get contacted. Why don't we do it and be proactive and do it first? Don't have your client, please tell your client, don't call the complaining witness. Don't you do it, let me do it. That could be witness tampering, and it's never good. Also, so okay, so if you can't, what you need to do is to get all the documents you can. Get the police reports. I can't tell you how many of my clients don't have them anymore. Go contact the former attorney, do a Freedom of Information Act. Sometimes I've had Oakland County for HIDA cases say, we can't give your client the police report, it's protected. I said, that is just ridiculous. It's his police report. Either I'm going to do a lawsuit against them or do a motion to compel discovery in court. But a prosecutor told me that the laws say we can't even give it to the defendant. So I don't know how that's going to turn out. Get a copy of the PSI, because that's just from my experience a couple weeks ago. There was something in there I didn't even know. Get that. Go and interview witnesses who were, if they were there, other people to say it was consensual. Paint a picture of it was consensual. Another thing I did is for the Romeo and Juliet petition, there was a really cute picture of my client and his girlfriend. He was kissing her on the side of the cheek, and I attached that as an exhibit. You know, if they have like, you can be as creative as you want. And, you know, I always think, did you go to homecoming with her? Okay, get the homecoming picture if they did. Or any notes she wrote him. Anything to prove it was a consensual relationship. You can do anything. Talk to the parents. They'll have a lot of parents can write an affidavit saying the girl came over to our house. They were boyfriend, girlfriend. I drove him to the dance. Just don't, like I said, don't take it as a slam dunk. Find everything you can to prove consent. So there's another way. So that was the Romeo and Juliet exception. It applies to new cases of people who didn't get HIDA, and old cases, even if they didn't get HIDA, you go back to the sentencing court to file that. There's another way to get relief from the registry. It's either for Tier 1 or Tier 3. Tier 2 offenders have no relief unless it's Romeo Juliet. For Tier 1 offenders, if they have done 10 years on the registry, they can petition, go back to the sentencing court, petition for immediate removal after 10 years. They have to have done it for 10 years. And there's all these factors on page 12. You'll see the factors the judges in this one, these reduced registration length, the judge can take anything into consideration. So all of the client's bad behaviors come in, likelihood to commit further offenses. That's why I do these. I have risk assessments done. Because judges, I mean, you've got to think about how judges feel in this situation. And sometimes it's a judge who just inherited the case. They get your motion. You say, I don't know who this person is. I don't want to be the person who takes this person off the registry and they go commit another crime and then I have egg on my face. And then all the newspapers come to me, say, Judge, why'd you remove that person from the registry? What I do is go send him to, I've used Dr. Gary Rasmussen, Leo Niffler from Eastwood Clinics. I know Matt Rosenberg does them, John Newman. There's a lot of experts in the area. Go have your client do a risk assessment, and then you can attach that to show they're not likely to reoffend. Also, sometimes that the person who's doing the report can also talk about whether it was consensual or not from their expert opinion. So in Tier 3 reductions, that will go from lifetime to 25 years, but that only applies to juveniles. So any adults convictions, they can't do it. These are Tier 3, those juveniles who are 14 to 16 with Tier 3 offense, they're the only ones who can do a reduced registration period. Also, there's automatic removals. They've taken out disorderly person, indecent or obscene conduct, also indecent exposure. Those no longer are registerable offenses. And then you can look on page 14 of my handout for the Romeo and Juliet, what can sodomy against a minor, if it's